If AI output has no copyright owner, who bears the liability when it infringes upon existing work? Does copyright protection for AI creations threaten the training data that built those models? Where's the line going to be drawn here for these machines? Reuters has this article, U.S. Supreme Court declines to hear dispute over copyrights for AI-generated material. So the U.S. Supreme Court has declined Monday to consider whether AI-generated art can be copyrighted, which is rejecting Missouri scientist Stephen Thaler's appeal. So there's been a sort of long-standing case that he's brought to different courts, and now it's been attempted to be escalated to the Supreme Court. The Supreme Court is, denying to see it. Now, Stephen Thaler has this system, DABUS. I can't remember exactly what it stands for, but it's basically saying it's a device for autonomous bootstrapping of unified sentience. That's what it is. But he wants to copyright this, the production of this, or what this system produces, okay? First of all, I have to question, why are people bringing this, to each court and trying to, raise it all the way to the Supreme Court? Partially, you have to recognize this is a PR technique where if things go to the Supreme Court and they get rejected or whatever, well, it gets covered by the news, And so if this inventor wants to get his name out in the world, wants people to know the name of his system, DABUS, and wants to get business through this is a way to do it. So even if they don't generate a copyright ruling in his favor or whatever, well, he benefits anyway, okay? So there's another angle to this. But let's take it at face value that this is, just trying to get a copyright for the things that the system produces. The court is saying, the opinion here is that copyright requires a human author. So if you want to have things that are just autonomously generated by a machine, it can't be copyrighted. It needs to have a human author. Now, we have really interesting things to talk about here. What's a human? Sure, we know what a human is, but what is author? And how does the human author think? So, if you're a musician, do you have to literally play the strings on the guitar, or can you use a computer to play those strings on a synthetic guitar? When the chords are generated, or the sounds from the chord that you selected are generated, did you do that as a human? Did you not, et cetera? Well, what about the person that trained the system, the DABUS system here? Who trained it? Didn't a human do that? Didn't it teach it how to do the things, right? And then you say, generate the thing. A human didn't tell it to generate the thing? Of course it did, right? So where's the line drawn, right? How do you define what a human author is? And anyway, but the Supreme Court rejected to hear it, so it sort of leaves that ruling intact for now. I have some questions for the audience here. So, if AI output has no copyright owner, who bears the liability when it infringes upon existing work? This is interesting, right? It might not be totally clear, but I would love to hear what people think about this. How about another one? Does copyright protection for AI creations threaten the training data that built those models? So you're using copyright in order to train the model. Okay, well, now it can generate things that maybe are in that style, et cetera. This is a very interesting gray area kind of question where think about this from a human perspective. We as humans can listen to music, right? And then we can create our own music, right? And we're able to get a copyright for it. We're a human author. We make that music. And yes, you can sue if your music is too similar to somebody else's music. But every pop song ever is the same, 3-chord progression, So where's the line drawn there, right? And we have figured out ways to do it, but where's the line going to be drawn here for these machines? So, will this push creative work behind paywalls faster than open source AI can commoditize it? This is an interesting question too. So one of the ways to protect copyright, protect your creations is to not put them on the internet freely available, basically. And there's case law around this. This basically means you have to put up a paywall that says anything behind this paywall, is not freely available on the internet. And the best way to think about this is like if you're walking down a public street and you look in the window of a store and you see something in that window, you see signage on it, you see what's inside, you see the merchandise that's there, et cetera. You can take a picture of it. You can study what's in there, et cetera. But as soon as you walk into the door, as soon as you're inside the premise, and now it's a different situation. But if you're doing this from the public street and they are enticing you in with their signage and that type of thing, totally fair game. And you can learn from it. You can take pictures of it. You could do all sorts of things. There's a similar analogy here for like if you make your website or work freely available on the internet, anybody can consume it, can see it, etc. It can be found by a search engine. It can be crawled by robots. It can do all of that. Well, then you're opening it up for fair use, basically. And one way to protect against fair use of your materials is to put up a paywall. And so, will this push? Will these types of rulings push creation behind a paywall, and so now it won't be as freely available, and so will that stifle creativity, and then will that just kind of snuff out this industry? I wonder about that. If you want to learn more and keep up to date with this quickly advancing world of AI, go ahead and like, comment, and subscribe. There's new episodes every week.